The amendments were actually rather vague. All they really say is that condo corporations can now hold electronic general meetings. The way they're worded is such that I think the implication is that there is now a right for owners to attend such meetings by virtual means. So even though, things are winding down with the pandemic, there's no more state of emergency, things are starting to get back to normal. Although that could change, who knows? It looks like virtual meetings are still here to stay for the foreseeable future. So even though some corporations will probably shift back to holding in-person meetings, there may still be a requirement for you to have a component to allow for virtual attendance if an owner expresses a desire to attend by that method. It may pose an additional administrative burden on condos, but that is the new reality. Virtual is here to stay.
But what's important is that you are documenting that those arrears are in place, because ultimately the board is the custodians for the entire project. It's fundamentally unfair to have the rest of the unit owners in the building carry the can for someone who's not making their necessary financial contributions. So I spend a lot of time working with boards saying, look, it's perfectly okay to defer fees, but you need to put a plan in place with those unit owners to make sure that you're actually going to recoup them, and that it's not swept under the rug. And, maybe if they start to pay again in the future, those arrears that they currently have, the unit owner likes to pretend that they don't exist anymore.
Unit owners sometimes get confused with the wording that boards are using. So I think also good advice to consult with your legal counsel to get some advice on how to communicate with the unit owner to ensure that you're not washing away old arrears, or you're not giving a misrepresentation to this owner that those arrears are somehow forgiven, or that the board is not going to come after the owner for them later at a later date. Noise complaints can be, they can come from a variety of sources. There's one type of noise complaint that's, where an owner is complaining about, or an occupant is complaining about the activities of another occupant. And the other type is where an owner or an occupant is complaining about the activities of the corporation. For example, undertaking repairs or maintenance, for example, replacing a roof. Did that corporation have, an expert's report saying that this must be done, that there is some structural issues perhaps that was needed, that needed to be addressed? Because if so, I don't think that's something that you want to ignore. There appears to be a problem. You need to seek advice from an appropriate expert, be it an engineer, an architect, a lawyer, whoever. And if they give you advice, it is always a good idea to act on that advice.
There's a variety of different types of noise that a building will produce. Some of it is going to absolutely be necessary. So again, if you have an engineer's report that says you absolutely have to fix this particular issue, that has to be done.